Hello, I'm Sandie Pendleton, and here are the 5 most common mistakes that businesses and organizations make regarding waivers of liability. The first most common mistake is copying someone else's release. The attitude that leads to this mistake is one of, hey, if it was good enough for them, it must be good enough for me. But that attitude fails to take into consideration that the release language may have been drafted with some other state's laws in mind, not your state's laws. That copied release may also not have been prepared or reviewed by an attorney knowledgeable about your operations and your state's laws about releases. Some states, including Wisconsin, are very strict when it comes to releases, and the layperson rarely is aware of all of the landmines that exist in this area of the law. Copying someone else's release may save you money in the short term, but in the long term, the amount you save is minuscule compared to what responding to just one claim is going to cost your business if you have an unenforceable release. The second most common mistake is trying to use an overly broad release. I frequently see releases that attempt to get the participant to agree that no matter what happens, the participant is giving up the right to sue. But in many states, such overbroad release language like that can lead to avoiding of the entire release. That's not the result you are trying to achieve when you go to all of that trouble of having your participants or members sign a release. The third most common mistake is using release language drafted by a national organization. That language may be perfectly valid in many states, but do you know if it's valid in your state? It may not be. In fact, there are at least 3 states where the courts or the legislatures have indicated that no pre-accident waiver of liability will be enforced. Do you operate in one of those 3 states or one of the other states where the courts apply very strict standards regarding waivers? You should know, so you can price your services and structure your risk management program appropriately. The fourth most common mistake is failing to handle the issue of minor participants correctly. Kids take risks. Kids get injured more often than adults. Juries are more sympathetic to injured kids than injured adults. Currently, there are about 15 states where courts or the legislatures have indicated that in those states, waivers signed by parents on behalf of their children will not be enforced. Do you know if you operate in one of those states? Again, you should know so you can price your services and structure your risk management program appropriately. The fifth most common mistake is failing to have your waiver terms address the issue of bargaining. One of the factors that courts consider, for example, in a state like Wisconsin, when determining the enforceability of a release, is whether the form itself addresses the issue of bargaining. If yours does not, and the vast majority I see do not, you've just increased your chances of being held liable. So, those are the 5 most common mistakes I see organizations make. But remember, there's many other mistakes that an organization can make when it comes to waivers. What may seem to your organization as a very reasonable, simple, or logical release may not appear that way to a judge or trial lawyer who is familiar with the many cases in many states that have invalidated many releases. Hey, if your business or organization relies on or wants to rely on releases of liability, visit our website, ReleaseLaw.com, to learn more about how we can help you use waivers correctly so as to lower your risk of liability. Remember, releases are important legal documents, which, if properly prepared and used correctly as part of an overall risk management program, can dramatically reduce an organization's risk of liability. If we can help you in this area of your operations, contact us. I'm Sandie Pendleton, and thanks for listening.
This audio recording, copyright 2010. The views expressed herein are a general discussion of the issues addressed, not legal advice. Persons having specific legal issues or questions should consult their own attorney or an attorney familiar with this area of the law.